Hello, everyone. I'm Alonzo Martinez, Associate General Counsel at HireRight, and joining me today is my friend Caroline Smith, HireRight's Vice President and Deputy Counsel. And this is Global Compliance Considerations for Criminal Records Checks. While Caroline and I are lawyers, today's webinar is not intended as legal or compliance advice. Our intentions are to give you information that you'll take as talking points to raise with your teams and your legal counsel. Before we begin, I want to cover a few housekeeping items. During this webinar, please take the conversation to X using the hashtag HireRightWebinar. In order to receive HRCI or SHRM credit, you must attend the full live session of this webinar. Credit information will be emailed to you next week. We are not providing copies of today's slides. However, we will send you an email with a link to a recording of this webinar session. If you are experiencing any audio or video issues, please refresh the browser window by clicking F5 on your keyboard or send us a message using the Q&A icon at the bottom of the screen. Doreen is producing today's webinar and will be monitoring the feed for any technical issues. After the presentation, we would appreciate getting your feedback. So please take our brief survey and let us know if this session was helpful. And again, please press F5 on your keyboard if you experience any audio or video issues. I used this analogy in our last compliance webinar, but creating a framework for global compliance in criminal records checks reminds me a lot of playing Tetris. I really like this analogy. I feel like it works particularly well. Every single piece that you drop, it has to be rotated just right and placed perfectly to fit into this growing structure. Similarly, every part of the approach to criminal records checks, it needs to be carefully crafted to fit within this diverse legal and cultural landscape of the countries that we're operating in. In our last webinar, we talked about how poorly placed Tetris pieces can leave gaps that make it tougher to move forward. The same goes for our criminal records checks. If we don't consider every angle, we run into compliance risks and operational headaches. What's really interesting is how these topics overlap. Both require us to stay flexible and adaptable as we navigate the changing regulations and cultural expectations. Our goal here is to build a strong and coherent system that not only meets compliance standards, but also supports fair and transparent hiring. By understanding these unique challenges in all the jurisdictions that we operate in, we position ourselves to make informed hiring decisions that protect our organization's reputation and help to ensure a safe workplace. So let's dive in today's discussion and let's explore how we can effectively manage these global compliance considerations together. Remember, this is intended to be an interactive discussion. So get your questions in using that Q&A icon. I'll be monitoring the questions feed. Caroline and I will answer them live in the context of the materials that we're discussing. So again, use that Q&A icon liberally to get your questions in. All right, so let's dive right in. Caroline, let's start at the very beginning. Why are criminal records checks essential for organizations operating globally?
So I think everybody agrees that criminal records are really a critical part of protecting an organization and its employees. And of course, they help mitigate risks that are associated with hiring candidates who may have undisclosed criminal histories. But specifically, we see 5 main reasons why folk will actually order criminal checks. So the first is protecting an organization's reputation. There's a potential for reputational damage if a criminal background check, for example, is overlooked. So that could be a company hiring an employee that's got a concealed criminal record. And that obviously can create some form of public backlash or legal repercussions and a loss of customer trust. Speaking of trust, it's really important to foster trust amongst your employees. And one of the ways that you can do that is ensure everybody that's working in your organization that the folks that they're working with have been properly vetted. Anybody is going to feel safer in that scenario. Then, of course, we've got legal and regulatory compliance. There'll be many of you that are on this webinar today who work in regulated industries, and some of those regulated industries require you to run a criminal check in order for your candidates to hold certain roles. So, for example, in healthcare or in financial services. And failing to conduct those proper checks not only lead you to breach those regulations, but again, let's go back to that first reason. If you fail to meet your regulatory requirements, you will suffer reputational damage if something goes wrong. The criminal check as well is a really great tool to help you assess any risk in relation to those individuals that you're hiring into your organization. And also, importantly, if any of you run rescreening programs, for you to continue to have that ongoing assessment of that risk. It allows you to understand if somebody does have some background that could potentially influence what records, for example, they might have access to, and things like that. And of course, as we talked about, trust, really all that does is enhance workplace safety. So again, if through your screening, you can identify candidates who can pose a risk to employee safety. And again, let's go back to the idea of rescreening as well. It's not just when you hire somebody, it's throughout the life cycle of that employment. And those proactive measures can reveal those candidates who do have potential safety risks. And of course, as I say, through the duration of anybody's lifetime or anybody's employment, that those risks can change. What's really important, though, is that any screening process has to be tailored. So, it's not one or more or all of those reasons may be reasons why you conduct a criminal check. And it's really important to understand for your own organization why you would do so, and then tailor all of your processes around that. And that tailoring will help you comply with the local laws and regulations that we'll dive into a little bit more in depth as this webinar goes on. So to sum up, conducting a criminal record check is really all about building a safer, more trustworthy workplace, and that robust screening process benefits the organisation by protecting its reputation and assets, and in some cases, such as regulated industries, ensures that you're demonstrating that you are meeting your legal and regulatory requirements.
And I think that tailoring background checks or screening programs, in particular as it relates to criminal checks, is really important. You and I speak with clients often, and there tends to be a desire to simplify processes as much as possible, which I completely appreciate. But by the same token, in many cases, criminal screening needs to be very nuanced in relation to the positions. I know you'll be talking about that a little bit, Caroline, but I think a really important takeaway that you provided is that there is not a one-size-fits-all model towards criminal checks. It really does need to be nuanced.
Absolutely. And those criminal record checks themselves differ quite significantly. And I think it is absolutely one of the biggest challenges for any organization to try and, make sense of the morass of laws, regulations, cultural nuances that can apply when we're looking at criminal records checks. It's so varied from country to country. And as I say, it's not just the laws that govern those checks, but it's also the type of check that's accessible, what rules apply when you're trying to access that information, and then essentially sort of what information is even delivered up by those criminal records. So it's really important to kind of understand what those differences are. So first of all, my favorite, obviously, data privacy laws and also employment laws really do affect the accessibility of criminal record information. So to give an example, Polish laws, data privacy laws don't, because they follow GDPR, don't prohibit the running of a criminal check or the processing of criminal data, provided you are in compliance with Article 10 of the GDPR and the Polish implementing legislation. But as soon as you put that in the context of employment, you have to look at the labor code in Poland. And that prohibits employers from conducting criminal checks unless there is some form of sectoral law that actually gives express permission. So financial services find they can do the criminal check. But really importantly, it actually prohibits keeping any criminal history information on file and or making a decision based off that information. So you have to look in lots of various different places just in one jurisdiction to figure out what may or may not be possible in terms of even running the check before you get started. Then once you've kind of established whether or not the criminal check can be run, you have to look at all the different criteria. So what's the criteria to constitute a reportable offence? And that can, again, differ significantly. So we see some jurisdictions where only serious crimes can be reported, while others can include lesser offences. And in addition to that, there's also jurisdictions that have laws that allow some offences to be, or all offences to be reported, regardless of their nature. depending on the role of the candidate and what they're going to be undertaking. So the UK is a fantastic example of that, with its varying levels of criminal check, our basic, standard and enhanced. And those latter two are only available if you're holding a certain type of role. And that's all controlled through legislation. There's also then jurisdictions where the process dictates that rather than getting a criminal history, which we might be used to, for example, in the United Kingdom, you get a certificate of good conduct. And that a good example of that is in the Netherlands. And in those cases, interestingly, the presence of the criminal offence is actually implied by the absence of the availability of the certificate of good conduct. So you'll only get that certificate if you don't have any criminal offence that actually the issuing body deems to be reportable from an employment perspective. So even at this level, there's lots and lots of complexity. Then we start to drill down into cultural expectations. So different jurisdictions have varying norms regarding the acceptability of criminal checks. So we have, for example, locations such as Germany, where we do have laws that say you are unable to run a third party, or an employer can't access federal criminal records. However, there is a practice in Germany where an employer will ask an individual to present them with a certificate of good conduct, for example. But culturally, because it can be deemed to be intrusive, regardless of the type of role, there is an underlying right to refuse to provide that information. And there, even if you had a criminal offence, and there's nothing the employer can do about that. So we have some really interesting cultural issues here. And then let's look at how you actually even access those sources. So we're very used to, under Article 10, knowing that consent is not something that you can necessarily rely on its own. You have to have an underlying reason or law that allows you to access a criminal record. Most criminal record bureaus, however, still have forms where you need to have an authorization and a signature. And you can, for the most part, have that submitted via a third party, such as HireRight. But in other jurisdictions, only the individual can go and get their own records. It's still the same form, but they have to go and get the records themselves. So again, everything is incredibly varied. So the practical implication for you as employers is that you really need to understand those variances in order for you to be able to roll out your programs so that they're compliant in different regions. And critically, it's really working with partners that can help you understand this, because it is so complicated. For example, we support something like 200 plus jurisdictions and territories. That's a lot to get your head around. And again, all of this really is just a signpost to this variability in criminal checks really does necessitate you to have a good sort of sit down and think about that tailored approach to your screening practices.
So Caroline, we're getting some incredible interaction from our audience. I'm looking at some of the questions that are coming in, and in particular, with respect to our first two topics, why should you conduct screening and how do criminal records checks differ? You mentioned, Caroline, that it's really important to work with a partner who understands from a regulatory and legal perspective how things work in country. We have some questions directly on point. So for example, a question coming in, will HireRight do the check to see if a criminal check is compliant to the relevant country's law or legislation before requesting that check and advising the requester accordingly? So how do we match up a particular country's laws to the services we deliver? Can you key on that, Caroline?
Yes, so that's really the partnership, either at the beginning of your relationship with a company like HireRight, when you're initially implementing. Again, there's a huge, it's like going to the best buffet in the world. There's lots and lots of products and countries to choose from, but you kind of need to get it right. So the teams very much will work with an organization to understand the business and the types of roles that are being hired into. And there's always people like myself and yourself, Alonzo, that will come along to these calls and really help give guidance and some benchmarking around what industry norms are for those types of roles. And that gives a really great indication. Importantly, though, every organization is different. So the ultimate decision as to whether a check can be run or not, especially in gnarly jurisdictions like the EU, where it's all about whether something's relevant and proportionate, the only entity that can actually make that determination is actually the hiring entity. But as I say, there's lots of information that we can use to support. And again, if programs are expanding, that's where you work with account managers. And again, they work with Alonzo and I to effectively help roll out those programs. There are, however, some jurisdictions, and the Netherlands is a great example, where in the forms themselves, you have to actually complete what type of role the individual is actually going to be applying for. And that form gets submitted to the authority, and they actually have a team of people. There's a whole group of people in the place called jurists in the Netherlands that actually look at the type of role that's been submitted on the form, and they actually then do their analysis of whether a record is reportable or not based on the role and the sector vertical that the individual's working in. So for the majority of those checks, once you've decided that you actually have a right to run the check, because we're going to an official government source, those government sources are then doing the filtering based on the information that is input on those forms requesting the criminal check. So it's a quite complex process that the majority of that is taken care of either with those initial discussions and then the types of sources that we're actually accessing.
So Caroline, you struck a chord with people when you mentioned Poland. Some questions coming in on Poland specifically, no surprise, right?
Yeah.
So we have an individual who says, great example of the Poland background checks. So how does HireRight identify what is being checked and what isn't being checked with respect to a specific country?
So well, we've all been around for a really, really long time. So we've built up a huge amount of knowledge, and we work with partners in various jurisdictions to ensure that any checks that we're running, are compliant and lawful. And we also work directly with sources as well. So, for example, in the UK, we're a responsible body, so we're registered. We're allowed to access those records on behalf of our customers. So we do that in a variety of ways. It's really all about making sure you keep on top of the law and monitoring all of those various differing laws. Of course, everybody had a huge refresh in the EU when we had the GDPR come into play, because Article 10 really did change the landscape for everybody. So there was a fresh review at that point, and that review is always ongoing. So it's really just leveraging our own internal expertise and the expertise of the sources that we work with.
And specific to Poland, there's questions about what is permissible within Poland. So, for example, are criminal checks permissible? Are global sanctions and enforcement checks permissible? Can you just give us a brief overview of what is permissible within Poland?
So generally, criminal checks are not permissible in the sense that we talk about criminal checks. So you can't go to a government source for employment purposes and request a criminal check on your candidates or your current staff if you're doing rescreening. As the general rule, it's prohibited under Article 22 of the Labour Code in Poland. As I say, you are unable to either make a hiring decision or retain criminal record information on your file. There are sector exceptions, so financial services, and this law is actually really quite new, and it's partly driven by a number of financial services organisations actually putting some of their back-end support in Poland. So the law was enacted that now allows financial services organisations to run criminal checks, because, of course, it's we go back to the first topic. One of the reasons why folk run criminal checks is to make sure they protect reputation and also comply with relevant laws and regulations. So that law in Poland was enacted to allow those criminal records to be run in respect to financial services candidates. It's also generally accepted that if you've got C-suite level folk who have, basically hold the reputation and also all the intellectual property and all the information about a company, they're generally allowed to have a criminal record check run in respect to them. But you would usually run those on a facilitated approach. So you'd have the individual go and get their own record as opposed to try and do that via a third party. So the general rule is you can't, but there are those exceptions. Now, global sanctions is interesting because some of those sanctions can sometimes include criminality information, but we would generally say things like terrorist watch lists, although that's obviously a criminal offence, would not be deemed to be the same type of criminal information that we're checking through a criminal record. What those records are looking at are things like fraud crimes or drunk driving or theft, those types of things, as opposed to something like a terrorism watch list. But again, most of the types of products that we have, that they can all be filtered via sources. So where there are concerns, if there is too much overlap, then that source can always be filtered out from a global sanctions check. So there's nuance within those products that allow you to still get a good sense of somebody's background in those jurisdictions where you have restrictions.
Let's take two more questions and then we'll move on to our next topic. So questions about individuals, organizations who did not initially perform screening of their applicants in the EU in particular as part of the pre-hire process, but now want to conduct post-hire screening. Is that a potential option for them?
Yes, it is. It's not without its risks. Neither is pre-employment screening. If we're talking specifically about Poland, for example, you actually can't legally do background screening checks until somebody's actually been employed and they're actually sitting in your office. So all of your checks in Poland, for example, are always going to be post-hire checks. Obviously not including criminal checks. But in other jurisdictions, background screening is something that in Europe and other jurisdictions has not necessarily been, it's not as prevalent or as normal as, for example, in the US. So there are lots of organizations that want to introduce background screening. So the first thing you always have to look at is what's beyond the criminal record piece. What would be my ground for screening? And that would be a legitimate business purpose. You can't rely on consent once that individual is employed. So you'd have to have a legitimate business purpose. And that goes back to the same reasons why you would conduct a criminal records check are often the same reasons that you would conduct any type of check. It's to protect your reputation, comply with laws, have your workplace as a safe place and a place where people want to come and turn up. So you have to kind of figure out what the reason for your screening program is. And for most employers, if you haven't already conducted a background screening check pre-employment, you would then need to look at your employee handbooks and your employment rules and make sure that you then are creating updates and introducing those effectively initial screening and then rescreening programs. There will be some jurisdictions, so Germany, Spain, Italy, where the introduction of screening as a new thing for new and current employees would need to be blessed by your works councils. But in general, it's always good to have some form of consultation with your employees. But the key here is to really, really drill down into the whys of actually doing any type of check when people aren't used to it, so that they understand that it's there for a reason. It's not just to be nosy, effectively.
So I think that's a really good segue. You mentioned that background screening outside of the US is not as prevalent, but is gaining traction. So let's talk about cultural sensitivities. How do cultural differences impact the acceptability of criminal checks in various countries? Tell us a little bit about that.
Yeah, and it all comes down to sort of cultural sensitivity. In some jurisdictions, a background check is quite normal. So for example, in the United Kingdom, the basic disclosure checks are very standard across the board. Most people going into a job these days will have a basic disclosure check run. And the reason it's so accepted is because it comes from a legitimate source. It's all pre-filtered, and it's only those offences that the legislation deems to be not rehabilitated and therefore acceptable for an employer to be aware of that get reported back. So, if you've done something silly when you were, 18 in your first week at university and you're now, 52, that's not going to appear on your record. So most people feel quite comfortable. Other jurisdictions, however, we really still see a culture of when you're being hired, there is an expectation of trust on both parts. So any type of looking into somebody's background can be seen to be intrusive. And of course, criminal records checks, whilst not defined specifically these days as sensitive personal data under the GDPR, has its own special article, and so is still deemed to be a more sensitive piece of information. So of course, in those jurisdictions where everything is done on more of a trust basis, it really does feel a little bit more intrusive. So really, what you're looking at is making sure that, the reason why, culturally that sensitivity is important is because if you do want to run the background screening checks, what you've got to be really aware of is that it's critical to be transparent about that, not hide anything. So we know that we have transparency obligations under our legislation, and that can sometimes feel a bit difficult to sort of figure out how you actually work with that. But actually, it's really helpful, because what you're doing is you're basically telling people what you're about to do. We're going to do a criminal check. These are the reasons we're going to do that criminal check. And that transparency actually helps to sort of smooth off the edges of those cultural issues that we can sometimes lean into. So it can be a challenge, but as long as we understand what those cultural nuances are, and as long as we are transparent and we continue to build that trust, then actually generally you're able to actually roll those criminal checks out in those jurisdictions where it's permissible.
So a few questions from our audience on this point. Again, thank you again for the participation from the audience. We appreciate getting your questions in. So questions regarding conducting background checks on independent contractors. Is that something that would be a norm in the EU or various parts of the world? Tell us a little bit about that.
Yeah, and we're actually starting to see a lot more of that. And I think that that's partly driven by the way that folk actually want to work. We're seeing more people, work independently of organisations or have portfolio careers, which lends itself to being an independent contractor. So we certainly do see those requests. And again, we always go back to, why are you screening? So what you're always trying to build is, whether it's an employee or an independent contractor, do you have a legitimate need to understand something about that individual's background? So if you're hiring an independent contractor to come in to do a particular, for example, IT contract, you would absolutely want to know that they had that experience, and that they hold the relevant qualifications if they are required to have them. That immediately justifies the fact that you would be doing those types of checks. Of course, those types of projects in and of themselves mean that independent contractor is actually going to see quite a lot of your confidential information. So you also want to make sure you understand a little bit more about their background. So criminal record checks, we talked about protecting reputation. Again, incredibly important, because you don't want that independent contractor to suddenly run off with the keys to your kingdom, sell it to everybody, or create some scandal by selling a scoop to a newspaper because they might be doing an IT project to shore up something that might have gone wrong within your organization. So it's all about building the story as to why you actually want to run those checks, why you have a legitimate interest to do so. And again, coming back to some of the things we've talked about, when you are running, making sure that these folk know that those checks are going to be done, be transparent. Why are you doing them? What kind of checks are you going to do? But yes, it's becoming increasingly normal to do.
One more question on cultural differences. What are your thoughts on self-disclosure of an individual's criminal history in the EU?
Yeah, so the self-disclosure path is something that's quite normal in some jurisdictions. As I say, I mentioned Germany, for example, where there's just a straightforward prohibition on a third party or an employer actually accessing federal criminal records. So you actually can't do it. But as I say, culturally, what tends to happen is, if the role merits it, if there's a legitimate reason, the employer will often ask the individual to provide a copy of a certificate of good standing. As I say, in some jurisdictions, an organisation like HireRight can't necessarily help with that. In other jurisdictions, you can actually, assist the candidate through that process by giving them the right forms, telling them where to go. And I think what's really interesting these days is the reason, one of the reasons why that self-disclosure has generally not wanted to be relied upon, especially in regulated industries, is because you again, going back to culture, you're going completely on trust, and it's quite a big thing to kind of go on trust. There's so much technology out there these days that actually there's an ability in most cases to be able to validate those self-declared certificates. So if somebody comes to you with their VOG from the Netherlands, there is technology that you can run to actually show that that's a valid certificate, or use a certificate number and actually get that validated as being a true certificate from the actual authority itself. So self-disclosure with the facilitated check, especially as we see the EU making it more challenging in some cases to get criminal records in the traditional way, is incredibly useful, provided you also use that with those third-party independent verification or validation tools.
So let's keep things moving. You're talking about a few countries. Let's keep things moving and talk about relevant global laws. So, what are some of the key laws that impact the way we conduct criminal checks outside of the United States?
So obviously, all of our favourites, the GDPR. So we have Article 10 in the GDPR, and that changed the way that we have to look at criminal record checks. Again, I always think about and I think this is because this is what I do for a living probably, but I always think of it as friend as opposed to foe. So when we look at criminal record checks, and we've obviously all acknowledged this today on the webinar, they're incredibly complicated. And Article 10, in effect, actually created, another obligation, sort of a eye roll time. But actually what it did do was tell us that we can do a criminal check provided that there's an underlying law and we obtain that information from an official source, effectively. So that means it's a lot easier for us to actually define what a criminal record product is, and also to be able to go and source the information from the correct place. And as somebody asked the question earlier on, that means that all of that information will be pre-filtered for employment purposes. So that legislation has actually made the criminal records process a lot more transparent and a lot easier to implement in some ways, albeit there's still all sorts of other laws you have to take into account. So we have the GDPR, and we've got the UK GDPR that also obviously mirrors the provisions in the GDPR. But for example, in the United Kingdom and in other jurisdictions, we have rehabilitation of offenders legislation. So you can go and you can get a criminal record, but all of that is filtered by the Rehabilitation of Offenders Act. So just because you have a criminal record doesn't mean that you're sort of on the outskirts for the rest of your days, effectively. So that introduces much more filtering, and again, that helps an employer because you can understand that the results you get back you can rely on. We've then got other jurisdictions where we're looking at criminal records checks. So if we look at, for example, somewhere like India, there's nothing in the current privacy laws that sort of prohibit you from doing a criminal record check. But interestingly, the new Indian privacy law, the Digital Personal Data Privacy Act, is effectively driving organisations and government departments to digitise all of their records. So again, when we look at legislation as friend or foe, that legislation is certainly friend, because it's incredibly difficult to do all the court searches within India. A lot of it has to be physical. But if those records could be properly digitized and searchable and have the appropriate filters put on them from employment purposes, that's a real game changer in the jurisdiction. And then if we look at something like the cultural changes and how the law affects that. If we look at, so for example, in Brazil with the LGPD has introduced the concepts of consent and transparency into any data processing. And actually in Brazil, a criminal check is actually something that is permissible for certain roles, but you can't use that information in a discriminatory way. Now, the privacy laws in and of themselves help with that because it allows you to do those assessments around proportionality, etc., and you'll be getting the consents. But conversely, the consent actually creates the transparency, which culturally, where people are a little bit nervous about criminal checks, can actually make people feel a little bit like, oh, hang on, why is this occurring? So there's lots and lots of checks and balances in different jurisdictions, and not getting it right and not understanding all of those varieties and patchworks can be a real risk issue for an organization. So to give an example of that, there's a case that occurred a couple of years ago in Spain, and the Spanish legislation is relatively sort of loosey-goosey. You have to follow Article 10. You're supposed to check whether there's underlying laws, etc. But there's a degree of assessing whether something is relevant and proportionate. And an organisation was fined a relatively large amount of money for running criminal checks in respect to some drivers. The argument was that, well, we need to know if they've got any offences. They're driving for a start, but also they're going to people's houses. And actually, the courts found that whilst there was a justification to do a check of some sort, there were less checks that could also achieve the same ends. And so they were fined and were told that for that particular cohort of employees, they weren't able to actually run those criminal checks anymore. So it is really critical to understand all of those nuances, and we acknowledge it's not easy.
So on this topic, a few questions coming in from our audience. One in particular about data retention. Can you talk a little bit about data retention and handling practices outside of the United States?
Yeah, so we again it varies jurisdiction to jurisdiction, which I think is probably going to be the biggest theme of this webinar. So there are some criminal record bureaus, for example, in Australia and also in the UK, that have very strict requirements in respect to the retention of consents for the background screening checks, and also access to those checks after a particular period of time. So, for example, the UK, the England and Wales DBS require us to retain all of the consents that have been used and submitted to the DBS for a period of 12 months. The same is true in Australia for the MPCS, but they've just introduced a new requirement that you can only access those records as an employer for 3 months after that check has been completed, and then after that you've got to reorder those checks. So some of the actual criminal record bureaus have their own specific rules, and they're obviously built into systems such as the HireRight system. But otherwise, what you're really doing is going back to the principles under privacy laws, which is you only retain records for as long as is necessary. Now, on the background screening platform side, that's going to be a relatively short amount of time. The background screening company will never know if somebody's hired or not hired, for example. So you want to keep that information for between 6 to 12 months usually, and that's what the European regulators sort of generally state in relation to retention of employment data. However, on your own employment records, where you are able to retain that type of information, you would retain that in accordance with the local laws on your own files and your own databases for the period of time that the local legislation allows you to retain those employment files for. Typically, that's anywhere between 5 and 7 years across Europe and most of APAC.
So let's keep things moving, and this is perfect timing because we just had a question come in that says any information about laws in the United States. So let me take you through this. So many of you who conduct screening in the United States know that our foundational law is the Fair Credit Reporting Act, or the FCRA. It's been around for around 50 years, and it regulates more than just credit reports. It regulates any consumer information. This is information about candidates and how that information is collected, used, and shared with you as employers. It requires several things. It requires that an employer provide a notice of that particular background check, and it needs to be a standalone notice. That is a point of litigation, frequent litigation. So employers have to give candidates that clear, informed notice and obtain their consent before a background check is conducted. If there is negative information in that background check, the Fair Credit Reporting Act mandates that employers follow a very specific process. We call it an adverse action process. We're going to talk a little bit more about adverse information shortly. But for you as employers, it means that in the United States, you have to notify the candidate of that potentially adverse information, provide them with a copy of the background check report, allow them a chance to respond to the information that they've been provided, and more importantly, also to dispute any information that is inaccurate or incomplete with the background check company, the consumer reporting agency, such as HireRight. So in a nutshell, the FCRA provides a process that is intended to promote transparency and fairness for that particular candidate. There's, of course, also various equal opportunity laws, most importantly at the federal level, Title VII of the Civil Rights Act of 1964, which prohibits discrimination on the basis of race, color, religion, sex, or national origin. When it comes to criminal records, this means that employers are asked to conduct an individualized assessment of those criminal records to that candidate's potential employment. So it's a unique individualized assessment based on that individual's criminal history. You can't make blanket assumptions based solely on a criminal record. Instead, you have to consider the nature of the offense, how long ago it occurred, and its relevance to that specific job. It's also important to remember that at the state and local level, many states have, and cities, municipalities have created their own laws that impose additional restrictions on background checks, in particular criminal history. Some states have implemented, states, cities, counties have implemented ban the box laws, which prohibit employers from asking about criminal history on initial job applications. They may also require things like individualized assessments be provided to the candidates. They could provide specific notices that need to be provided to the candidates. Again, very nuanced based on that particular jurisdiction's requirements. So the variations require employers to be both vigilant as well as proactive, I would say, with respect to how they handle compliance at the local level, state level, as well as federal regulations. And remember that it's like Caroline mentioned, this is a very nuanced process. So if you are hiring individuals from outside of the United States, for example, in Europe, you need to consider any potential overlap that may occur between non-US law as well as things like the Fair Credit Reporting Act. Let me see if you have any questions out here. Questions concerning consent with respect to the United States. Yes, it is a standalone consent. There are some states that require additional notices be provided. California, for example, requires its own standalone notice. We have more information available for you in 2 white papers that we published. We can send them to you as part of the email to this particular webinar, one on credit information, so information that talks about how credit information and more specifically states may limit the information that an employer can consider, and then a larger white paper on ban the box laws. Like I mentioned, those limit criminal history inquiries and provide, in some cases, additional requirements on employers, such as individualized assessments or specific notices. Both of those white papers are really good resources for you to expand your education journey on this. I mentioned credit checks. Caroline, there's actually a question about credit checks in the UK. Can you jump in and just cover that? What is permissible? Is it an option for employers in certain industries?
Yeah, so credit checks actually are completely normal in the United Kingdom at the moment. I will caveat with that. So most organizations actually run them. So they're run through the credit bureaus, and there's specific products that are basically used for employment purposes. So everything is filtered with that in mind. So you're not getting, it's not like in the US where you get a complete full report on somebody's credit and it shows any bit of credit they've ever had in their lives. It's really looking at adverse credit. So as I say, it's all appropriately filtered. So it will show if you've got any bad debts, county court judgments, any bankruptcies, etc. Obviously very frequently used in the financial services, but any finance role or any role that might have some degree of risk associated with that, and they're also what we call soft credit reports. So they don't actually create any impact on somebody's credit score. It doesn't show up that one has been run. So it's a very specific product that is accessed. I said I caveat that with it being normal, and that's because the Information Commissioner's Office has actually written a white paper, and there's been some consultations that some of you may have actually been involved with in respect to processing data in an employment context, and background screening is one of those items. And actually the Information Commissioner's Office is really very much now focusing on the idea of relevancy and proportionality. So in respect to credit checks specifically, the ICO's position at the moment is pending any finalization of that the organizations will have to take a little bit more thought around whether or not running that credit check is actually relevant to the individual, to the understanding of the individual's background in context of them holding a specific role. So I think that at the moment, everyone does it pretty much. We may see that changing a little bit depending on the outcome of the Information Commissioner's guidance.
Let me wrap up with 2 more questions regarding criminal checks in the US. A question from the audience concerning the FCRA process. The question is it a requirement to send a physical copy of the background check report to the candidate if we initiate the pre-adverse action process? And the answer to that is yes. So remember, as part of the pre-adverse action process, if you may take an adverse action, meaning that you might impact that individual's employment, whether it be removing their conditional job offer or if they're an existing employee, terminating them, demoting them, anything anything that could be adverse. As part of the pre-adverse action process, you need to provide them with a summary of their rights under the Fair Credit Reporting Act, a copy of their background check, as well as provide them an opportunity to dispute the information within that background check. So again, that's the accuracy or completeness of the background check. The FCRA doesn't tell us how many days you have to provide that opportunity, that dispute opportunity. The Equal Employment Opportunity Commission, I'm sorry, the Federal Trade Commission has issued an opinion letter that says that 5 business days is probably a reasonable amount of time. So a minimum of 5 business days is what I would say. And then if you do choose to move forward with the adverse action process, you also have to provide an adverse action notice along with the individual's summary of rights under the FCRA. So that is the FCRA pre-adverse and adverse action process. Remember, though, the entire compliance process requires that you provide a standalone notice of the background check before you conduct the background check, receive the candidate's express authorization for that background check, certify that you have a permissible purpose before requesting that background check, and then follow the pre-adverse and adverse action process if you are going to make an adverse action. One more question about how if HireRight supports both U.S. and non-U.S. criminal checks, both within the same report. So let's say an individual is a U.S. worker, is going to work in the United States, but let's say they lived abroad for some period of time. So the answer to the question is yes, we can conduct checks as permissible within those locations and include that within the U.S. screening report for your review. So let's keep things moving as we only have around 15 minutes left, and Caroline and I have a few more topics to cover. So let's talk about data privacy, Caroline. What are the key data privacy considerations and candidates' rights that employers should be considerate about during the background check process?
Yeah, and we've covered quite a lot of these because the themes permeate. So really the key data privacy consideration when running a criminal check is Article 10. That's where we start and end effectively. So make sure we understand what Article 10 says. So we can run a criminal background check provided there's an underlying law and we obtain that information from an official source. So that's our starting point. And then really it's the general principles that apply throughout the legislation. There'll obviously be some other things in implementing laws or other standalone laws in jurisdictions, but we're making sure that the individual has adequate notice. So we'll always display an information notice first, letting that candidate know that a criminal check is going to be done and explaining how. So to the question asked before, the candidates are told that their background screening check will be a check of their criminal records in all of their disclosed locations over a particular period of time, for example. We'll always let individuals know what their rights are. Those rights don't change just because it's a criminal record check. So an individual is perfectly at liberty to ask for a copy of their report from their prospective employer, and for them to then be able to dispute the information that's contained in that report. We talk about informed consent. As I say, what you're really doing initially is making sure that you've got a legitimate interest and legitimate grounds to run those criminal checks. And then what we're doing is we're getting an authorization to do so. But for certain jurisdictions and certain sources, we have to get a consent form signed, for example, the UK DBS. And then, of course, in terms of data handling, and it goes without saying, for any type of data handling, whether it's an employment verification or criminal record verification, you have to ensure that all that data is handled in compliance with relevant laws. So making sure that there are appropriate technical and security measures in place to safeguard that information. And all of those things really just allow those criminal checks or any checks that you're undertaking to run much more smoothly.
So I think that's a good segue into our next topic. And in particular, we just received a question saying, is criminal screening in Mexico, how about criminal screening in Mexico? Is it worth performing? So let's talk about some common limitations on criminal records. Tell us a little bit about that and maybe cue into this question about Mexico as well.
Yeah, so the record limitations we touched on right at the beginning, because there's various ways of getting to a criminal record and various methodologies, and that's all determined at a jurisdictional level. So, for example, as we've mentioned frequently, we've got the Disclosure and Barring Service in England and Wales, and the equivalent bureaus in Scotland and Northern Ireland, and they hold all of the records, criminal records of every person in the UK who has a criminal record, obviously. And when you submit those records, you have to say why you're submitting the records, and then the bureau itself filters all of those records. There are many, Switzerland, France, all sorts of jurisdictions across Europe and APAC that work in that manner. So in terms of a limitation, the limitation in respect to those records are what does the law permit an employer to see? But thankfully, that's all taken care of. There'll be certain things in jurisdictions. So, for example, in Italy and in India, youth and juvenile offences, that they can't be reported out. And as I say, in the UK, you have expunged and sealed offences, which are only shown on a criminal record if the employer has the ability to ask a standard or an enhanced question. So a great example of that would be a doctor. If you're employing a doctor in a hospital, you can ask for that enhanced check. Or if you're working as a senior manager function in financial service, you can also ask for that check. And there's around about 20 sort of job types that allow you to ask for those checks. Specifically relating to somewhere like Mexico, it's got a really quite complex landscape, not only in terms of what you can actually access, but reliability. So it really goes back to sort of what we were talking about in the first couple of slides, which is working with a partner who understands the correct source or the correct mix of sources that can be brought together to actually deliver you a check that's meaningful. If, for example, you just went and kind of said, "Oh, go and get your own police record from your local police station in Mexico," that's not necessarily going to be terribly helpful to you. The likelihood is that that's just somebody giving somebody, a few dollars under the table and they get something back. So what you're really doing is looking at the different sources available. So official sources, court records, public information. There are a variety of different levels of courts within Mexico, and understanding the different types of offences that can get reported in those various sources, and then amalgamating all of those into a criminal check that gives you meaningful results effectively. So it's so important to understand, or for us as a background screening company, to understand those limitations, so that where it's not as straightforward as going to the actual Criminal Records Bureau itself, you can still look at the data available and get those meaningful insights into your candidate populace.
So speaking of these limitations, I think that a good question just came in talking about limitations with Russia. Can you talk a little bit about how criminal records screening works in Russia and some of the in-country limitations there as well?
Yeah, so Russia, just in general, is pretty difficult to sort of navigate. Of course, we have sanctions that we have to look at. So the first place that we would always start with is, if we're doing any types of checks in Russia, is the bureau that or the source that we're actually working with, is it on the current sanctions list in any of, either the EU, Japanese, or US sanctions lists. What then actually happens in Russia is that you have to work with a fully licensed partner who has a license to go and look at those records. Again, you would always make sure, as we have, that individual is not listed as an individual on any of those sanctions lists. So that individual will go to the particular to the relevant location, and will effectively make notes on any cases that are available and then report those back. They will then look against the relevant laws in jurisdiction to make sure that those cases are reportable, and then report back. But it's quite an old-fashioned and strange system, it has to be said. But as I say, the first place to start is to make sure that those sources and your licensed partner, and they have to be fully licensed, is not on that sanctions list.
So I'm going to skip ahead, Caroline, as we're in our last 7 minutes here, to adverse media searches. So can you explain what adverse media searches are and why they're important as part of the background check process?
Yeah, so there's two types of adverse media searches. There's an adverse media search that's conducted across sources that are in the English language, and then there's media searches that are conducted in local language. And they are basically looking at any information that's been publicly reported that is either adverse or points to somebody's bad conduct that has been bad enough to be reported publicly, i.e. there's no restriction. So anyone can see it if they happen to sort of read the paper, for example. And the reason that these checks are important, well, there's two reasons why they're important. One, they can be supplemental to your background screening report. It gives you much more, a great insight into somebody. If they've done something that might not be typically reported as an offence, for example, you'd still be able to see kind of what they've been up to. But typically they are often used in jurisdictions where it's just prohibited to run a criminal check of any kind. So we would see, for example, a lot of organisations in locations such as Germany or South Korea would use these media searches. So, for example, in South Korea, a criminal record check, for example, is not prohibited, but the data that you need to actually access the record is the RRN number. It's the only way you can access and then accurately report back. And the legislation prevents you from processing the RRN number, so effectively blocks through another avenue access to criminal records. However, the risks are still there in the organisations that used to run those records pre-2016 or 2015. So what we find is that rather than saying, okay, well, we can't check anything, we run these media searches. And again, if something is so bad that it's been publicly reported, generally legislation will say that if you have the right to see that information due to the nature of the role, then it's absolutely fine for that to be reported. And then you can review and make your hiring decisions based off of that.
So as we are in our last 4 minutes, let's wrap everything up, Caroline. So what are some best practices and key considerations that employers should follow when conducting criminal checks globally?
So the best practice is to take a nuanced approach. Whilst it's super tempting to have a one-size-fits-all, I think the general theme here is that it's an incredibly complex landscape. There's lots of nuance, whether that's at the legal side or the cultural side, or just how you actually access sources. So you need to take a nuanced approach to make sure that you're compliant with relevant laws. So to do that, again, you must sit down within your organisations and conduct an analysis of what's relevant and proportionate in the different cohorts of the different roles you'll be screening against. So that's the first piece. The second is to know your risk tolerance, or those two things kind of go together, because that's your risk tolerance really informs your idea of whether you've got a legitimate interest to run these checks. So know what the risks are in your business, and they can change over time. In different organizations, or a risk that didn't exist before can suddenly pop up. You may have an event in your organization that makes you relook at your screening programs. There was a question earlier about, well, if I haven't screened before, can I decide to do that after the event? Well, yes, and particularly if a risk has actually emerged during your organization's history. So knowing your risk tolerance is really important as well. And again, let's go back to the fact that this is incredibly complicated as an area. So working with a partner in your screening provider that has all of this sort of, to hand and understands the complex backgrounds, has people on the ground across the jurisdictions that understand those cultural nuances as well, is really important. And all three of those things should add up to you being able to run criminal record checks in jurisdictions where it's permitted, safe in the knowledge that you can rely on those results and hire the right people in your organizations and mitigate your risks.
So, Caroline, we are nearing the end of today's session. So thank you so much for your insights and expertise. It's always a pleasure collaborating with you on these important topics. A lot of information we provided to our audience today, and to our viewers, we appreciate you taking the time to join us today. Before you sign off, please take a moment to complete the brief survey at the end of the webinar. It really helps us improve our future sessions and tailor our content to your needs. Let us know what you want to see and let us know how we did. look for your credit information, SHRM and HRCI credit information next week. Again, we will email out a recording, a link to a recording of this particular webinar. And again, there were several hundred of you on today's webinar, over 1,000 registered. Thank you for your amazing participation. You helped make today's conversation a success. We'll keep answering your questions even after this webinar session as part of a blog series. So with that, we look forward to seeing you at a future HireRight webinar. Until then, make it a great day, everyone. Thanks again.